Thank you very much. Thank you, INCIBE. Thank you all for being here in this panel. The truth is that this topic is very well chosen. Let's look at some countries, such as some American state, as California, that was the first public power that officially recognized data leakage, even before about thinking to have a data protection regulation. Canada has also regulated this issue. The state of Alberta was the first one to do so. Korea, South Africa. This is like a general and worldwide wave of data leakage regulation, and Europe, of course, couldn't be left aside of this. As you may know, Europe from 2018, or especially the European Union, has started to impose a regulation on data leakage, and these obligations are defined on the Data Protection Regulation of 2016 and the ENISE directive. As you may know, both regulations are applicable from this year. They must be implemented this year. So 2018 is the year of data leakage, of security leakage. So this is the topic we are going to discuss here, and I think the panelists couldn't be better for this topic.
Tienen perfiles muy destacados en sus ámbitos y donde además cada uno han sido muy elegidos por INCIBE, hay que reconocerlo, tiene un perfil muy marcado en cuanto a los temas que vamos a abordar. Belen Arribas Sánchez es responsable, es jurista digital ante todo y lleva muchos años también en estos temas, es una de las pioneras en España y en concreto en el área catalana, en particular en Barcelona, pero en el conjunto de España también. Y es responsable de estos temas, como no, en la empresa de abogados, iba a decir, en el despacho de abogados Andersen Tax and Legal. Nos acompaña también Daniel Escoda, que es una de las personas más marcadas desde el ángulo legal en Telefónica y en concreto dentro del grupo de Telefónica en Telefónica de España, porque es el director de los asuntos regulatorios, legales y en general de regulación de las comunicaciones en esa empresa dentro de ese grupo. Paco Pérez, bueno, pues sin Paco no estaríamos ahora mismo aquí. Es también jurista digital y en este momento es el secretario general de INCIBE. De manera que poco más tengo que añadir, aparte de reiterarle las gracias. Y Andrés Calvo es coordinador tecnológico dentro de la Agencia Española de Protección de Datos. Y sin duda, por lo tanto, una de las voces más autorizadas dentro de la agencia para hablar de este tema. Incluso me atrevería a decir que yo diría la voz más autorizada para hablar desde el ámbito tecnológico con, si quieren, el gorro de la Agencia Española de Protección de Datos. Pues sin más introducciones, y si les parece, y les explico un poco también el formato de la mesa para que lo puedan seguir con más facilidad, vamos a ir dando paso a los ponentes. La idea es que ellos expongan durante aproximadamente 5 minutos su visión del problema, del asunto que vamos a tocar, y posteriormente abriremos un pequeño debate introducido con algunas preguntas que yo iré formulando consecutivamente a los ponentes. Si sobrara algo de tiempo, abriríamos probablemente
some time, of course, we will give the audience the opportunity to ask some questions. And without further ado, Mr. Andrés, please. Thank you so much, Pablo. Thank you so much, INCIBE, for having invited me to this event once again. And, well, without further ado, I would like to talk about my experience after 6 months of the regulation, of the implementation of regulations. We have had 300 leakage in the company. Well, some of them cannot be considered as leakage because even though they can be considered as leakage for some institutions or breaches, they do not affect the data of people, or this doesn't affect the freedoms and liberty of people. I could listen to previous speakers talking about this, and there is something we must take into account. This is changing the scenario, and the regulations, therefore, are changing. And some companies, some entities had already adapted to these changes, but there are some other companies, like mine, that is still trying to deal with this change. I'm talking about data protection regulations, other type of regulations.
A todas las empresas de nuestro tejido industrial.
Change means challenge for people in charge of dealing with this. Because data protection regulation is not anymore a formal compliance issue. We used to have some files before that we had to complete, and that was it. But nowadays, regulation makes things clearer, and now regulation says you don't have to be compliant just one day. Data protection is not a status, it's a process. Same thing as security. Security is not a status, it's a process. Data protection is also a process. And you must take into account data protection in all the process of your organization in a horizontal way. And in some aspects also in a vertical way. You cannot forget about data protection. Because there are some things here if you forget about that data protection. If something happens, your business is going to be harmed. You're going to see some tangible damage. But you're also going to have some intangible damage, the reputation of your company or your reputation as businessman or businesswoman. It's going to be put into question. And maybe you cannot assess this damage in the mid or in the long term because it's not something you can foresee. So how can you apply regulation? How can you well understand the regulation? It's a tool to enforce reliability in your company. We cannot think that regulations is like, okay, I have some processes, I'm going to keep them there, and I will review them in a couple of years. No, regulation doesn't mean that. Regulation is saying that all the organizations must be involved in complying with this. All your clients need to know that you are doing things right, because if an authority wants to control your company, they are going to ask you to show that you are complying correctly with the regulation, that you are doing things right. Because before we had these files we had to complete or to review from time to time. Every 2 years we had to audit this information, but it doesn't work like this anymore. Now this is a continuous process. The process is alive. It's not something that we can leave aside. It's a whole process, and we have to reach all employees, and we need to show this to all of our clients, because this is an added value for our companies. And well, I wanted to be brief, so this is all I have to say.
Muchas gracias, Andrés. Francisco Pérez, por INCIBE.
Pues la verdad es que, como sabéis, la parte que me corresponde a mí, yo no tanto en el reglamento, pero acaba de explicar muy bien.
Well, I think Andrés has explained very well the regulation, but regarding the ENISE regulation, we've managed to transpose this directive, and I think this goes in the same direction as Andrés is explaining regarding the regulation. This also involves a change regarding the data protection, and we are not talking anymore about having this type of process that is reviewed every 2 years, but now this defines an internal culture of cybersecurity, and this is and companies now are forced to keep this process alive, this process that involves cybersecurity and data protection. This must be part of the core unit of the company. A businessman or a businesswoman need to have in their strategies some data protection programs or strategies. We are making companies responsible of the information they are working with. Also, the directive explains the responsibilities of regarding the information, and companies now are forced to have a permanent program that deals with data protection and security. So the question right now is, are we ready to change our mindset? Before I had to comply some test type documents, and now I have to adapt to a new reality. So this is like turning our legislation into a different model of legislation. Before, we were forced to comply with several points. If the company complied with these points, you were okay. But now this doesn't work anymore. This is a continuous process, as we've seen, and this is a challenge for the industry. And also, I'd like to comment some of the aspects of this new royal decree that has been established. I would like to mention the legal terms included in this decree. I think this can involve some problems regarding the interpretation of the legislation. For example, the royal decree talks about disturbing aspects, and it establishes some parameters that are going to be assessed depending on the case. So it also talks about needed information. We will have to make an effort to see if the information we are talking about is needed or not. It also talks about reputation damage. So as Andrés was saying, in the legislation we are including some aspects related to company reputation. What are we talking about when we are talking about damage to reputation? And it also talks about the agreements between providers that are done with a delay or without a delay. Another element I would like to emphasize, and that I think it's really interesting, is the notifier protection. We are not talking here about whistleblowers, but it's true that providers that are in charge of notifications are kind of protected so that they do not suffer damage from having notified this type of activities. And lastly, and this is the last thing I want to say for now, it also talks about the notification channels, because for us, one thing that is very important, taking into account this royal decree, we have here a specific computer emergency response team to deal with this issue. We already have this figure, but this is going to be like the reference for all companies in case of notification of security breaches. I'm not just talking about data leakage, but I'm also talking about security breaches. And notifying these breaches to the center of reference is going to make us design some notification protocols. Companies will have to make clear how to notify these data leakage, and this is going to be a challenge for the future. And also, some companies have already mentioned the fact of having to unify platforms. So it's not that I just have to notify a problem to the administration. I have to also notify. Do I have to notify also the breach to the reference center? Are all these platforms going to be connected? The royal decree already mentions in the Article 29 that these platforms will have to be interconnected so that the citizen or the company will have to notify these issues in the most simple way possible. Thank you so much, Paco. Daniel? Well, thank you so much for having invited me on behalf of Telefónica. I think after the implementation of this regulation, companies have shown that they have been working in the right direction. I'm not just talking about the telecommunication sector, but in general, there is no doubt that big companies have already decided that we need to have the right protocols to address security breaches. And this is defining when talking about succeeding or not in managing security breach right. So having a right protocol means to have enough technical and organizational measures to respond to a critical situation, and a situation in which time has a very important impact at the legal level. It's not that we have to mitigate some risks. I'm talking that sometimes we can be in problems if we do not notify these breaches on time. So I think companies have been working in the right direction, and that protocols have been established to detect security breach. We have internal hackers, ethical hackers, then we have different type of alarms and connections, for example, cooperations with companies also such as INCIBE. We need to have designed how to solve these security breaches, because I'm sure that companies have a crisis committees to deal with these situations and to let know to all the different departments of company where is the mistake. In the sector of telecommunication, we have three types of notifications. Of course, we have the notification that comes from the data protection regulation, but we also have data security protocols. We also have data. We have protocols regarding of the type of services you are providing. So in the industry of telecommunication, we already had assumed the challenge that we had to organize our companies to respond as fast as possible to the needs. And there is something basic we must say about this, especially taking into account the different experiences we've suffered. We've reported 3 incidents regarding data protection lately. And it's very important to have the right training and the right knowledge inside companies, so that everyone needs, because everyone needs to know how to answer to these questions. And I would recommend to do some type of test. These are the best things we can do to be ready to face the 72 hours challenge. From the legal point of view, the biggest challenge is to be able to know what's going on. And in order to do so, it's very important to have security teams that are ready to act and that are ready to cooperate between different departments to be aware as fast as possible about what's going on, because this is the big challenge that we have to face when we are facing this type of situations.
Belen Arribas,
I think you are going to give a presentation. Yes, if you allow me, I have to take the remote control, which is there. I'm going to start by thanking Pablo for your presentation, your introduction, and of course thanks to INCIBE for having invited me to this event. Thanks, of course, to Andersen Tax and Legal. I've prepared this presentation, but I must say that my colleagues have already said many of the things I wanted to present right now. But also, they have given me the perfect excuse to give this presentation I had prepared. I'm going to try to be brief. Of course, we had to talk about the applicable regulations. We've been talking about this for the last 2 days. We are talking about the data protection regulation, the ENISE directive, that both of them have been transposed by the correspondent royal decrees. But as you know, we also have some cybersecurity regulations distributed in different bodies. We don't have a single institution in charge of that. We have different regulations about data, about different issues of related to these topics. We have the regulation about cybercrimes in the criminal code, for example. We have the regulations about computer emergency response teams. So we have different type of regulations distributed in different documents that deal with cybersecurity aspects. We have this GDPR regulation, and who are the people in charge of this? Well, as you know, the person in charge of treatment of data protection is in charge of this, and they are the ones deciding what to do with data. And then we have the person, that physical or legal person that treats this personal data for the execution of a service agreement. Well, as you may know, the person in charge is only going to answer in case of damage if this person has not complied with the regulations applicable and the instructions that have been given to them. So what security measures are covered by this regulation? Well, as you know, we need to take the technical and organization measures that are appropriate to guarantee an appropriate level of security. We also have the need to have an assessment of the risk to freedoms of people involved. Also, there is the need to ask for advice to the authorities, and also it's established that member states can also define some proofs of compliance that will be mandatory. What's new in these regulations? Well, we've been talking about this in these last 2 days. Companies for the first time need to notify authorities that a cyber attack or cyber event or security breach have happened. So this is a new obligation. Internationally, as you know, this is not something new, and our clients sometimes were wondering what to do in this case of security breaches. Until May, we could say that in Spain, we were not forced to notify this type of events, but from now on, we have to start working in a different business culture. So the person in charge will have to notify the person responsible of this, that will have to notify the competent authorities in 72 hours, and also they will have to notify those people affected in case there is a high risk to damage liberties and rights of these people. As for sanctions, you already know what's established in the regulation. This is something new too. Here you can see the prescription, deadlines. Depends on the turnover of the global turnover of the organization. Also, the individuals also have the opportunity to ask for a compensation for damage suffered. So, this is the responsibilities that companies must face. Now I'm going to talk about the ENISE directive, because I'm not going to explain it again because Paco has already said enough. So this is the scope of application. Companies that render essential services to the community, and the information networks for the development of the activity. Also digital service providers such as search engines or cloud providers. As for the obligations, the adoption of technical and organizational measures, as Paco was saying, language of the Royal Decree similar to the language of the directive. Also, the appointment of a security person in charge of the information, notification of incidents, and also appointment of different staff. Finally, the legal framework implies the possibility of notifying the public, and I was also asked to explain that against this legal effort at the European and at the national level, in Spain there are more and more cyber attacks, and the number of cyber attacks are increasing. You already have heard about the most recent cases because we've read them in the press. There was an important event. You all know Equifax, rating agency in North America, which is present in many countries. 143 million profiles were stolen. This involves more than 200,000 credit card data. This happened because they didn't update their software. Also, the high management tried to delay the notification. There was a leak of managers, and they suffered a sanction of 500,000 euros in the UK, which is not bad, even though this happened before the transposition of the directive. Facebook, you've heard about this issue too. More than 50 million data were leaked, were stolen. Millions of tokens were stolen. I think there was a fine of 12 million euros in Spain, and of course the reputational damage was even higher than this fine that they had to pay. This also must take into account the Cambridge Data Analytics event that dealt with the elections in the United States, and in the end, Mark Zuckerberg had to go to the American Congress to explain the situation. And we are seeing that the stocks of Facebook are continuously decreasing in the stock exchange, and Facebook stakeholders are of course asking for a change of the president of Facebook. Uber, you already know about this case. They pay computing pirates in order to avoid talking about this issue publicly. Finally, a year later, they notified this issue, and they had to pay a fine of more than 100 million euros. I'm going to talk about two more examples, and that's all I will say. Google Plus, I'm sure you all have heard about this. There was a vulnerability exposure in March 2018. Data from thousands of users were exposed, and they decided not to communicate this event in order to avoid consequences. But in the end, they had to close temporary Google Plus. Then we have British Airbus, T-Mobile, Job and Alert. In the press, we can read every day some cases of cyber events, cyber attacks, security breaches, and this is a new scenario that is here, and that will be here in the future too. So speakers have been very obedient, and we are on time, but we have to keep on working this way. We are going to start with some questions. I'm going to start asking a question to Andrés Calvo. Why do you think, Andrés, that your agency thinks this is especially important, the issue of security breach? Well, we are directly involved. These breaches are not formal notifications. The fact of addressing breaches are processes, as I've said before, that we must comply with. And notifying breaches are the real expressions that show that this process is being done. I cannot try to make breaches as a formal issue. I cannot say, okay, I have these procedures to deal with breaches and I'm doing fine already. No. When we have a breach, we have an opportunity to show that we have some accountability criteria that are appropriate for your business. So this is why breaches are important. Do you have some experience already about how the sector, or, well, how sectors in general are implementing these regulations? Well, we've had last month 20 notifications of breaches. Since the regulation was implemented, we have had 300 notifications, so the response is being quite good. But the response, I think, as I've said, is being quite positive in general terms. Thank you very much. I would like to take the opportunity to mention that, of course, you can intervene at any time you want to. So, and it's not, this is not going to be a bilateral conversation with each speaker. I have another question for Paco. Paco, sanctions. What's the perspective of INCIBE regarding sanctions, and especially taking into account critical infrastructures that may be a more sensitive issue here? Well, there are some other institutions that are more in charge of critical infrastructures, but it's true that nowadays the directive and the royal decree includes a sanctioning regime. So the critical infrastructure law had some problems because it didn't include a sanctioning regime that could force critical providers to comply with different criteria such as audits. But this is changing now because not only we have a sanctioning regime, but there is something new here, and I want to read something from the royal decree. We are trying to promote the avoidance of an infraction instead of sanction of these infractions. So from the legal point of view, we are working a lot on prevention, not that much that on reactions. And this is also has some implications regarding the sanctioning regime, because we are talking about the administrative sanctioning regime. So having a good behavior or good protocols is going to decrease the legal responsibility of providers. But it's important to mention that there are different types of sanctions depending on the type of incident, serious incident, average or low impact incidents. But I would like to mention some of the things that are new also in this transposition. For example, there are different amount of sanctions that can be applied. The most serious incident can get to 1 million euros, and also sanctions we take into account the use of the providers of bug bounty programs. We've been talking about bug bounty programs before. These are regimes that in Spain are completely unknown, but now the directives and the new regulation is inviting companies to have this type of rewarding programs for ethical hacking activities. So we have to try to incorporate in our companies these new positions or roles we can start also using this type of bug bounty program. This would be an invitation for the creation of this type of programs in Spain. And also, the regulation says that when the provider recognizes that they are guilty of a breach, this also is going to work in their favor. So this mix in the regulation is going to allow us to have different type of sanctions, which I don't think is an easy task, but it's a type of traditional regime, but it's also complemented with some new aspects that are very positive, I think. Thank you very much, Paco, for your answer. Daniel, maybe from the point of view of big companies, you can give us your opinion regarding this issue. I want to especially know about what's really happening in big companies. How are big companies putting this into practice? I know that you can only talk on behalf of Telefónica, but do you know how this implementation is taken into place, the implementation of this new regulation? How are big companies doing in Spain? Especially in Spain. And regarding specific protocols, do you think that, do you know there are some problems regarding the particular protocols of action? I really like your idea of doing some tests. What can you say about this? Well, as Telefónica is a specifically complex company and regulated company. So having a good protocol that covers every element, data protection, I mean, or critical infrastructure security, or essential services provision, this increases even more the complexity of protocols because we need to have different measures in every aspect. And I was saying before, time is very important. Lawyers usually work with time pressure. I was used to work with weeks or months time pressure, but now we have hours time pressure. So this is very important to take into account. And what I must say is that all companies need to have protocols depending on their realities or their needs. A company that is highly regulated or a company that has different branches implies that they need to have protocols adapted to this situation. In Telefónica, for example, we have identified some type of champion, so to speak, for each operating unit that are in charge of ensuring that all the problems, all the information that we have collected are integrated in these protocols. As we are a technology company, we need to imply these solutions that at the same time we are selling our clients. In order, I'm talking about instant messaging programs, or so that in crisis situations we can have specific chats or spaces in which we can obtain the needed information about what's going on. And regarding the 3 incidents I had to face recently, 2 of them happened before the implementation of the regulation and 1 afterwards. As I was saying before, one of the most important or critical moments that are going to define if notifications must take into place is being aware that there has been a violation of data. as Andrés was saying before, so one thing is that we have security incidents from time to time. We cannot be reporting this type of security incidents that happen from time to time. We have to report those incidents that have an impact on data protection. So we had to sit and say what's the defining moment in which these 72 hours are going to start counting. This is very important. And what we've realized is that we need to identify different type of moments. One is the existence of a potential vulnerability. The second moment is when a vulnerability is being exploited from the point of view of hacking, for example. When a vulnerability is starting to be exploited, then if there is an impact on data protection, we would have an event. And afterwards comes the moment when we are aware of this, of the impact of this act, and this is when the 72-hour period starts counting. Because it's not, we have different types of attacks. It's not the same having a ransomware than a direct hacking, than a physical attack. So it's crucial to have security people that knows if an element or an incident is violating personal data. And this is this is very important, and the security protocols of each company must deal with this. Because I'm sure that, well, cybersecurity, you know that cybersecurity is an area in which lawyers and businessmen and businesswomen from the company, communication staff from the company, they all work together. We are not just talking about the IT department or legal department working in this issue. Cybersecurity is an area in which many departments have to work together in order to solve situations, and in a matter of hours. Yes, this is basic. Companies have communication departments, they have chief data officers, they have DPOs, they have call centers, such as in Telefónica, we have the 1004 number, and legal departments. So the only way of acting in the right way is having the cooperation of all the departments. We cannot see that the call center is giving one response, the communication department is giving a different response to the media, the lawyer is thinking that nothing should be notified. So decisions need to be made in the right way, and this involves the cooperation of all departments. I think I've mentioned this already in this forum. Nowadays, we cannot talk about cybersecurity as something different from cybersecurity. Nowadays, all cybersecurity involves security. The digital world has an implication everywhere. But I think awareness raising is key in the question I'm going to ask. What do you think about this raising awareness process regarding the clients you are working with? Companies are already aware of the responsibilities they need to face, and I'm especially talking here about SMEs. You are completely right, Pablo. And this, and it depends on clients. It's true that it's not the same talking about SMEs or big companies. Big companies are usually more into technology. I'm talking about the utilities sector, banking sector, the public administration sector. These companies are know very well security technology issues, but in case of SMEs or even particular professionals, it's true that the awareness raising issue is improving, but maybe the budget of this type of companies is not improving, because these small and medium companies, of course, understand prevention involves more expenses than investments. So we have a path to follow in this direction in order to raise more awareness in this type of companies, because if a client is selling online, cannot calls you on a Friday at 12, cannot call you to say, okay, I cannot use my web page have been blocked, I don't know what to do. But if your website, if your base is your basic asset for your business, you need to have an action plan to deal with this type of situations. And maybe SMEs cannot devote that many resources in this regard, but there are some things that they can do, such as risk analysis. They need to analyze the risk they can face. Also, they have to establish some action protocols in order to coordinate the different players within the company, as Pablo has mentioned before. Also, you need to raise awareness between your staff, because the human element is always the weakest element in a chain. So you have to raise awareness. You need to know that there are tools and companies that can help you, such as INCIBE. Sometimes companies don't know that there is some companies such as INCIBE that can help them. And finally, or well, not finally, but they also should have a cyber insurance depending on the risks that its company is facing and on the subject that they can devote, that they can allocate to this issue. There are many things that they can do. These are our recommendations. Well, I don't know if you want to say something else, but I think that maybe we can give the audience the opportunity to ask some questions. Maybe we can have 2 questions max top. And please, I would like to ask you, to the audience, to be brief when asking your questions. Well, the organization is saying that we can have 1 question. I have a very short question. For an SME, the biggest challenge is to know that they have a security breach, because sometimes SMEs that have adapted to the data protection regulation, they have adapted to this and they have another folder to deal with this, and they think that they have already complied with these regulations. So what do you think SMEs can face these challenges? Because SMEs are 90% of companies, and there are lawyers, there are people in charge of this, but I don't know if they are fully complying with this. Well, one of the main concerns of the agency are our SMEs. We are aware of the situation. In fact, the certification scheme we are working on is already implies this. We want to deliver some quality in the market so that SMEs can count on professionals that go beyond the registry or the specific compliance of some points of the regulations. I have to also encourage or congratulate the effort that big companies are doing, because this effort means that SMEs that are working for big companies have an example to follow. They are learning from big companies, because big companies are demanding SMEs to comply with the same models they are complying with. So I think this effort is very important, and we have to emphasize it. And it's true that more than 98% of companies in Spain are SMEs. So our company environment needs a lot to have more guidelines, because in the end, this compliance is going to be an added value for companies. Companies are going to be competitive if they can ensure data protection of clients. If there is a company that cannot guarantee the integrity of my data, then I'm not going to trust this company. I'm not going to, I won't want to work with this company, or I'm going to prefer to work with different companies that can ensure the protection of my data. And the agency is going trying to make an effort to make this work easier for companies from SMEs. There are, of course, SMEs that cannot put into practice data protection measures on their own. There are some of them that can. And we also have a channel in which we try to give a response to problems to this type of SMEs that sometimes do not know how to put into practice these regulations or have some questions regarding this. I would like to mention something, which is that notifications, of course, are important. Notifications are important, and if you don't notify, you are going to face a fine. But inside companies, if you have to give priority to something, is the mitigation of the impact of a security breach. This is basic. This must be priority, the priority of the company. And this is something that sometimes the security person in charge of finding out what's going on is the same person that has to do an operating work and has to change passwords. So first of all, the company needs to address mitigation of the damage, and then they need to notify. I agree with you, because first of all, companies need to protect liberties and freedom of people, and they need to ensure data protection. And afterwards, notification can be done. Notifications can be done in different times, but first of all, people need to be protected. Belen, I can give you half a second, but we are running out of time already. I'm going to give an answer to this woman. I think that we need to devote time to data protection. This is what I'm always saying to my clients. And we need to devote time to selecting service providers, in case these SMEs need some service providers in this regard. I wouldn't trust service providers that offer a low-cost service, because sometimes they are not going to be there with you if you have some problems or some incidents. So please, you have to devote some time and some more resources to this issue, and do not always trust these low-cost companies, because sometimes they do not offer enough security. Data protection is one of the things we must take into account, but there are a lot of things that we need to take into account too. Fake security is a problem that is there, and we need to know that this is a task, a pending task. We have to execute, and we have to do it as good as other type of tasks. And please, I would like to invite you to use all the resources that INCIBE is offering, and whose aim is to try to help these companies to deal with these issues. Thank you so much to all of the speakers, and thank you to the audience.